advertised. Hey, this backpack is good as advertised.
Wow. I might have to get on that.
Yeah, mine's like a Swiss gear one.
There you go. A few things before we start.
A little damp, but not too bad.
First, I've gotten through quite a few of your snapshot reviews on Causation. I've gotten through it. If you handed it in or emailed it to me before Friday, I've done yours. The ones from Friday, I haven't gotten to yet, but I'll start those this afternoon. So I've gotten through quite a few. They're good. Some missteps, but that's to be expected. I will try to put up model answers on Blackboard this afternoon, so you can look at those. And I will also try to have your comments to you on yours individually back to you on Wednesday. Quite a few of you gave them to me on Friday, which was fine, but it does mean it'll be a little harder to get through them all by Wednesday, but I'll try. So that's one thing. Any questions about that? Hope that's clear. Okay. Second, we're going to do something a little funky today. I hope you'll bear with it. I've always wanted to do this.
Funky chicken.
And now you're all thinking, oh my God, what's he about to say?
I'm
And that is, I want to cover the cases on our agenda for today out of order. I personally think that Rizzo should be before McWhorter. I've always meant to put it on the syllabus that way, and I always forget when I do the syllabus. So we're just going to do it. We're going to do Rizzo before McWhorter and see how it goes. So get yourselves ready for that. And I think it makes more sense that way to follow Murray with Rizzo and then go to McWhorter. With all due respect to our casebook authors, sometimes you can have a little different approach. So that's something I want to alert you to, that we will start with Rizzo. Okay? And last but not least, yesterday was my birthday.
Happy birthday!
And one of the things I always like to do on my birthday, because I don't know what I like to do, is I like to bake. I like to bake anyway, but I especially like to do it on my birthday. And so I have for you today cookies. There are some with nuts and there are some with no nuts. So I'm just going to pass them around. Take a cookie if you want one. Don't take one if you don't want one. There's no pressure, right? And the one that has no nuts is labeled. It says no nuts. And the one that's not labeled at all has nuts in it. So if you don't like nuts, first of all, you're crazy. But if you're allergic, I get that completely. So anyway, these are for you guys. You start those around. As we go. Okay. Anything on your minds? Yeah, it's easy. I have all these announcements and getting sent. Nothing. So we'll start with Rizzo. Okay. And then go back to McWhorter. Okay. What was Rizzo convicted of? What was Rizzo convicted of?
Attempted robbery in the first degree.
Good job.
Attempt to commit robbery in the first degree.
And we're trying to do pretty much what we did in Murray, right? Which is to draw the line between attempt and acts in preparation to commit the crime if the opportunity presented itself, right? So what did Rizzo and his compatriots do? I have no heads. Go ahead.
All right. So
I will look for a pen while you talk.
Rizzo and his three compatriots, what are their names? Dorio, Milo, and Tomasello, plan to rob this Charles Rayo, who worked at United Lading Company. They got in a car and they rode around looking for Rayo.
so they're in this automobile, right? They're in this automobile, and what was the plan, other than just generally to rob him? Were there any more specifics?
Well,
How do they intend to carry this out, in other words?
Well, they went to the bank, and then well, yeah, they were. I guess they were going to stick him up. Right?
Well, yeah, that's pretty broad. Was there any more specifics in their plan? Mr. Razor?
Rizzo was gonna identify Rose and then
Yeah, apparently he knew, or at least could identify him, and then?
two of his compatriots that had firearms were gonna actually do the robbery.
So everyone had a role to play in this plan, at least. So what happened? What actually happened? And then we'll talk about what didn't happen. What actually happened along the path to this robbery?
They discovered that they were being followed by police, and they ended up like dispersing.
And they've been driving around for a while, as you said, right?
Right.
And then they said, wait a minute, something funny's going on here. The
Yeah.
police are maybe on to us. And so what does Rizzo do?
Rizzo. What went up?
It's intimidating.
Clemens?
He jumps out of the car.
Yeah, he jumps out of the car, runs into a building, and everyone's arrested. Okay? If you were representing Rizzo, what would you, in the facts, point out had not happened?
That he didn't identify Rayo. Rayo was not there.
Okay? So that was his job, the task he had not been done. What else would you say had not happened? Or was not true in the circumstances? Ms. Hartman? It had not yet happened. If the robbery had happened, what would he be charged with?
Just robbery.
I'm sorry?
Robbery.
Robbery.
Plus attempted.
So the mere fact that the robbery hadn't happened isn't going to clear him of attempted robbery, right? That's certainly helpful, because to some extent. What else had not happened?
Any substantial step?
Well, that's a legal conclusion. I'm talking about just the facts. On the facts, what had not happened?
The payroll was never picked up.
The payroll hadn't been picked up, right? No one with a payroll had been seen at any, forget Ralph for a minute, no one with a payroll had been seen at any of the places that they were. What else?
No crime had been committed, they had just been driving around.
They had just been driving around, okay. No, again, that's sort of like, well, they hadn't actually completed the robbery. That doesn't get us as where we need to go defending Rizzo from an attempt, though. Ms. Clemens?
The firearms were never used as a method of fear or actually shot at all.
What about Ralph?
You could argue he jumped out of the car. Well, Raul was never present, never even existed.
Rao was not there when they arrested these guys, right? Rao was not at the place where they were arrested in this. So there's a lot of facts to suggest, or you could argue, at least if you're the defense, suggest this wasn't even an attempt, right? They were looking for him. They had not seen or discovered the person they were going to rob up at the time they were arrested. So let's put up our timeline, right? This is the mere thought. And we go along our timeline towards completed crime. And on our timeline, we have driving around. We have planning with specific roles for each conspirator. We have armed, but we don't have ID of Rao. We don't have Rao at bank or wherever, right? And we don't have payroll delivered. Okay, where are we in terms of, given these facts, is this an attempt? Where on the side of the line are we?
Mere preparation.
This is, all of this, the court says, is mere preparation. And what would have to be true to take it beyond mere preparation? What's the definition? Mere preparation, we know, is not attempt. What would make it attempt? What's the measure by which we decide whether it's attempt?
A substantial step.
No. That would be if we were looking at this case today.
Increase the likelihood of.
No. What are we looking for? There.
Direct steps towards the commission.
No, it's not steps towards commission. No.
It must be so near completion, result success is very great.
The so near completion. Give me more. How near completion?
Like the step right before.
How near completion? That's good. I need something more.
Dangerous proximity.
Dangerous proximity.
Oh, yeah.
Under this test, all of you had sort of pieces of this. Under this test, it's not merely that how many steps he's taken, Rizzo's taken from here. It's how close he gets to here. And how close does that have to be under this common law test? Dangerously near. Dangerous proximity. Just like you had to be dangerously near marrying your niece in Murray for the attempted incest charge, he has to be dangerously near robbing the bank, right? Have to be very close. So the line is drawn here. Not here, really, but really close. Really close. This dangerous proximity test. Okay? And obviously, or maybe it's not so obvious, the court says, we don't want to focus on all the steps that might tend towards completion, right? Arming yourself, driving around, assigning roles. They might tend towards completion. They are too remote. We must be so near to the accomplishment of the crime that it would have been committed but for timely interference, right? So if it hadn't been, they have to be so near that we know it would have been committed if the police hadn't gotten involved. We know that this crime would have been committed. Do we? Do we know that this crime would have been committed if the police hadn't been on to the Rizzo gang?
I think you could say no because they might not have ever found.
Right,
Yeah.
right? They might not have ever found the payroll they were looking for. So it's speculative whether the crime would have been committed. They must be dangerously near. Now, what do you think of the dangerous proximity test? Johnson?
It puts pressure on police,
Pressure on police, why?
because you pretty much have to wait for someone to do something and fail or be in the act kind of to get them guilty or be
And,
really close to it.
And if you wait, what's the risk if you're a police officer?
Uh,
If you arrest too soon, what happens?
That they get off, like in
And
this
what if
case.
you were and so you're going to err on the side of,
Caution?
well, what does that mean? You're going to, if you were afraid that they're going to get off, they're
Yeah.
going to not be able to be convicted even of attempt. If you intervene too soon, what's your instinct or your training even going to tell you better do?
Arrest them before they...
If you arrest them too soon, they're going to get off, right?
Okay, yeah.
What are you going to do?
I'm going to wait for them
You're going to wait.
Yeah.
You're going to wait. And if you wait, what might happen?
Then they're going to commit the crime.
You may wait too long,
Yeah.
right? If you wait too long, how are the people in the bank going to feel?
Yeah.
Huh?
Yeah, no, they're
How
going
are
to be
they gonna
scared.
feel?
They're going to feel
Just say,
robbed.
yeah, tell me how they're going to feel.
They're going to feel bad.
They're gonna feel bad.
They're gonna feel
How bad?
like a crime was committed,
The
right?
crime was committed. And what might have happened while this crime was committed?
In danger. They'd be in danger.
Is inherent in the term dangerous proximity that we have what? Danger!
Yeah.
Right? We have danger. Somebody might, during a bank robbery, what might happen?
Somebody might get shot.
Somebody
killed.
might get killed. Because the police said, you know what? Forget it. The courts have told me I better wait till they are right on the precipice of committing this crime. Right? So, And, police aren't perfect. Police, have to make judgment calls, and the law is telling them they better wait to make sure they don't go step in too soon, and the error might lead them to wait too long, and then danger happens.
So would the biggest problem with dangerous proximity test be that it's almost too subjective?
It's not that it's too subjective. It's a test. The problem with subjective tests is that they are uncertain, is that you don't know how to interpret them. This is a clear rule, but it raises concerns about its application, right? Like any rule, even a clear rule, right? This rule says we know that this crime would have been committed, and anything before that is mere preparation. Anything before that is mere preparation. Right? So I don't think the problem is that it's subjective. The problem is the implications. The implications are, we're going to have people put in danger. And the criminal law doesn't particularly like that. So that is the critique of the dangerous proximity test. If this was the common law rule and was being applied in your state's courts, and you were in the state legislature, let's say you were an aide to the Judiciary Committee, and you were tasked with writing a memo urging reform, you would say the problem, or the biggest problem with the dangerous proximity test is that it does not lead to effective enforcement of the law. It does many situations which we should regard as attempt in order to protect the public at large, as the criminal law should do. Those would not be seen as attempt under this approach. We need a different approach. Okay? That would be the argument, I think the strongest at least argument you would make. So that's the case against the dangerous proximity test. That's the weakness in that test. Now I want to go back to McWhorter. So we've sort of made this case with both Murray and Rizzo, right? By requiring the act to be so close, you raise real concerns in the law. Okay? And Murray, it might seem like, well, okay, the danger isn't quite. You can always have the marriage annulled. There's no great harm in requiring a great showing of coming near. Rizzo shows that there can be real danger because of the nature of the crime. Let's talk about McWhorter, a very different kind of case, that may teach us a very different lesson. So what happened in June of 1951 in Atmore, Alabama? Ms. Cervera.
The defendant was in the parking lot of the Tiny Diner, in the cab of a truck, when Mrs. Ted Allen walked by with 3 young girls after getting Cokes at the diner. She testified that that McWhorter followed her home and made remarks that he or made it seem like he was following her and wanted to rape her, and
Did she ever say that?
Mm-mm.
The following home part, yes.
Okay.
Does she ever say that? Does her testimony provide any evidence of his intent? Okay, but she does say that he followed her. What did she do?
she feels threatened, so she stops first at one doorstep and waits for him to pass, and then after he's passed, she goes back and starts walking again, but then he was waiting for her up ahead, so she has her daughter run to the neighbor, and the neighbor then comes out, and that's when she is able to get away from him.
Yeah, this is the Lufkin house, right? She goes onto the home of Sue Lufkin, waits 10 minutes for McWhorter to pass. McWhorter comes toward her from behind the telephone pole, she says. She had the children get Mr. Simmons, and it was only when McWhorter saw Simmons, according to Allen, that he turned and went down the street and just stayed across the street, right? She watched him for half an hour from Simmons's porch. He then left, or she says, and she went home, okay? And there's some corroboration of this from Allen's daughter.
Right.
What does McWhorter say?
That he was just waiting in the parking lot. He was going to go to the area of town, the front, where his friend was, which is an area of town where he was allowed to be because it was for people or black people, and that he had no intentions to follow her. He wasn't following her.
Yeah, they had come to Atmore. He says they were on their way from Pensacola to Monroeville. They stopped there to eat. Of course, they had to eat only in the colored section of the diner because of segregation, Jim Crow. And he, as you say, he went to look for Paige, the friend. And he said, he saw Allen, he said, I'm going to wait until they were gone because of his concerns about how that might be perceived. Okay, so very different events. He said he didn't do anything that was directed at or had any connection to Allen. Allen says he followed her and came at her, etc. Okay? As I said, even from her testimony, even from Allen's version of events, there's nothing that would be evidence regarding McWhorter's intention. Okay? And he was found guilty of what crime?
Intent to rape.
Well, attempt to commit an assault with intent to rape. Okay, so we have attempt to commit an assault with intent to rape. Where is the evidence of this intent to rape? Where does that come from? As we said, it doesn't really come from Allen's testimony, but there is some evidence. What is it?
The police, chief of police testimony.
And what did the chief of police testify McWhorter told him in jail while McWhorter was in jail?
That he was going to get the first white woman that walked past him to rape her, and that she was the first one, and that he started off behind her with that intention.
Now, Mr. Vera, I have a question for you.
Yes.
He said, the police chief says that McWhorter told him, I don't have any money, I'm going to rape the first white woman that comes along, carry her in the cotton patch, and if she hollered, I'm going to kill her. On a scale of 1 to 10, 1 being completely and totally impossible in your mind, and 10 being not only possible but certain, how likely do you think it is that McWhorter in 1951 would have said this to the chief of police in Atmore, Alabama?
A -10.
Negative 10, right? Right? Why not? Why do you say negative 10?
Because he had everything against him. He's a black man, and the chief of police is probably a white man,
I think
and
we can safely assume that, yes.
everything from the laws to where he could sit in the restaurant to where he could be in town, everything went against who he was.
Good. In a nutshell, what are these words? What are the implications of these words if he'd said them to the chief of police? For McWhorter, what are the implications?
Oh, that he's confessing to what they're trying to charge him with.
And he's basically convicting himself.
Mm-hmm.
He's basically convicting himself, given the criminal justice system, its operation, and what he faces. What else does the Court of Appeals say constitutes evidence of McWhorter's intent, besides the chief of police's testimony?
The chief deputy sheriff corroborates the testimony.
Okay, but that goes to the statements McWhorter made. both the chief of police and corroborating, besides the statements that they say McWhorter made, what else does the Court of Appeals say constitutes evidence?
It says that the jury may consider social conditions.
Keep going, go on.
May consider social conditions and customs founded upon racial differences, such that the prosecutress was a white woman and was best as a Negro man.
Social conditions such that, social conditions founded upon racial differences such as that the prosecutrix was a white woman and defendant was a Negro man. What do you suppose the court meant in saying that race was relevant to judging intent? He was black, she was white, that's relevant evidence.
I think commonly during this time, people who were vehemently racist thought that black people were incapable of the moral standing that white people had. So it's saying that you have to judge the black man as like less likely to be able to understand the immorality of his actions and less likely to kind of defend against those urges to do bad. That's like the thought process of racism.
What else?
I think they maybe just wanted to make the statement, if you're black, stay away from all white people.
I beg your pardon?
I think they wanted to make the statement, if you're a black man, stay away from white people, or stay away from, our white women.
And what does it mean? What does it mean in terms of the social expectations of staying away or not staying away?
I think it just further sets that divide, and it just says this is off limits. It might not be illegal for black men to have relations with white women, but we kind of want to say it's not going to be accepted, and you better watch out if you even try it. Because
What did Allen say McWhorter did with respect to this point about quote unquote staying away?
Followed her.
He followed her, or to put it another way, he didn't stay away. And what is the implicit assumption that the court is apparently, or at least one way you can read the court, that the court is saying the implicit assumption about a black man who doesn't keep the appropriate distance that social conditions and norms tell him he's supposed to keep?
Shows that he's becoming more equal, or there's a state of inequality.
Yes, it certainly shows inequality. What else does it show?
Doesn't it move the line that closer to the complete?
I want to talk about that in a second, but I want to talk about what does it say about intent?
It just implies that he's trying to rape her just because he's
Right, the court is saying the only reason, given these social conditions, that a black man would come near a white woman must be that he had this intent. It could only be. And who's making these decisions? Who do you think? You said Mr. Rivera says we can assume that the chief of police was white. Who's on the jury?
White people from the area.
Who's on the Court of Appeals?
White.
So all of these stereotype racist assumptions about the behavior of black men, imputing to them intent to be violent, intent to be threatening, simply by their mere presence where they are not supposed to be, becomes evidence that they in fact had that intent. So what does that, and now, I think it was Mr. Cannon who said about moving the line. Talk to me about that.
Well, like, if you think about separating preparation.
This was attempt to commit assault,
Right.
and then we added the attempt to rape.
Right. So they're saying that dangerous proximity for a black man in this circumstance, it's moved over, right?
And this is pre-model penal code, right? Model penal code, the rules don't matter.
Right.
Racism matters, right? So instead of it being truly, it has to be dangerous proximity, what is he being convicted of attempt with?
Like what? I mean,
At most, what can you characterize his actions as?
I mean, preparation, quote
At
unquote.
most,
At best.
right? Now, that's assuming that we think that what seems like innocent steps of simply being in a place, right? that those seemingly innocent steps could be construed as in some way corroborating his intention, right? But they would seem like they are mere preparation under the rule we've been adopting, under the rule we've been operating under from Rizzo and Murray, right? So we have a different rule for black people and white people, and black people especially charged with assault with intent to rape being in this time and place when it came to black men and white women, an especially fraught issue when it came to the danger that black men faced of injustice in the criminal justice system. So, if we talked about what were the weaknesses in the dangerous proximity test, what lessons or issues does McWhorter raise about attempt? Right, this one said, when we did Rizzo, he said, well, maybe that requires police, law enforcement to have to wait too long until the defendant gets too near to completion. What do we get out of this, Mr. Johnson?
There wasn't enough, I want to use the word steps, but
Okay, there weren't enough steps to show what?
To completion? Or towards completion?
Let's assume for the moment that we have the mere thought on McWhorter's part.
Mm-hmm.
He did very little, and what risks, and if we allow him to be convicted, what does that tell us about attempt?
We got to
With
convict.
few steps from here.
That it's influenced by prejudice?
I beg your pardon?
That it can be easily influenced by prejudice?
Easily influenced by prejudice,
Or
good.
is prejudicial?
That there are tremendous risks of unjust prosecutions, right? Because if we can convict on nothing or very little from here, remember the Oklahoma case about the guy who simply owned a building.
Mm-hmm.
Like, well, that's an innocent act. And the court said, no, you can't convict somebody because they haven't done an act. Here, McWhorter raises similar concerns. If we don't require at least something beyond this, and I mean, again, where we're going to draw the line, then maybe it's racism, maybe it's overzealous prosecution, whatever it is that may infect the criminal justice system. If we don't require this, the risk could be we don't require enough, right? So what does this, if at one extreme we have a problem, and another extreme we have a problem? Anybody remember any children's stories that this might remind you of?
Three Bears.
I beg your pardon?
Goldilocks and the Three Bears.
Yes, why?
Because you have three options in each scenario. One is on one extreme, one's on the other extreme, but the third option is right in the middle. It's the middle ground.
We have the porridge is too hot, we have the porridge is too cold, and now we have to get it just right. But we only have two options right now. We have the option where the law enforcement can intervene based on virtually nothing and prosecute people for whom there seems to be no real evidence of their criminal intent or the steps they've taken to fulfill it. Or we can wait and convict them only when they are so close that we put the whole general public at risk. And that's where the model penal code comes in. The model penal code is your bed that's just right. Right? Not too soft, mattress is not too hard. At least that's the argument. What this draft is the model penal code we're looking for was something that would protect against unjust prosecutions where all you really have are a few steps that don't tell us much about what was really going on with the defendant, but you don't want to have the prosecution wait too long. And what was the model penal code's answer? What was the compromise in the model penal code between these two extreme risks?
How many steps have they taken from here?
Not just how many, there's something about the steps. What about the steps?
Substantial step?
They have to be A, substantial. Can even be just one, although that's unusual. But in theory, it can just be one substantial step. And substantial seems awfully fuzzy as a term. It's like, oh, substantial, okay, what's substantial? Well, there's a particular definition of substantiality in the model penal code. What makes a step or steps substantial within the meaning of the model penal code's definition of intent? Substantial in that it or they,
The steps show criminal purpose.
I beg your pardon?
The steps show criminal purpose.
Not just show, give me a little more, right on it. It's about criminal purpose. What more?
Is it they tend to the activity in a particular direction?
A little more.
Is it strongly corroborated?
Strongly corroborate. Let me put an asterisk here. And there's our definition of substantial. The steps must strongly corroborate the defendant's criminal purpose. What outcome in Rizzo or Murray under the model penal code test? What would be the outcome? If I gave you an exam question with steps similar to or parallel, analogous to Rizzo and Murray, and I told you to apply the model penal code, what would your answer be?
My answer would be like, it would be attempts since like.
Because?
Because like with Rizzo, like they were there at the thing with firearms. And then like with Murray, like he has pretty much everything set up besides like taking those vows.
Do you have any doubt in Murray, for example, what his criminal purpose was? That he actually had the purpose and he wasn't just innocently going on a vacation with his niece?
No.
Right? He did enough things. He asked to go get the magistrate. And he went off with her. So you have enough there to strongly corroborate criminal purpose. Right? Same facts, but once we move away from the dangerous proximity test, back here, we can now convict. Same with Rizzo. The conspirators did enough stuff that I at least think is closer case, but I think you at least get to a jury, and a rational jury could convict beyond a reasonable doubt that they did enough that I'm convinced of their intent. Closer case than Murray, but I think we get there.
I have a question about in the McWhorter case, did the court claim to be using any of those tests that the common law test? I know in the Rizzo case they said dangerous proximity, which was extreme this way. Is there another one of those tests that they're claiming to be using that was?
Did you find one?
No, that's
What test do you think they were using?
Their own.
What test do you think they were using? I've heard it a few times, sort of, but not from you, Ms. Richter. They were using the test that black people go to jail.
Okay, so they weren't using
Black men did what we're going to accuse them of doing, and the rules don't apply. Right? The rule of the time should have been this.
Okay.
And if Rizzo couldn't be convicted under that, and if Murray couldn't be convicted under that, God knows McWhorter shouldn't have been able to be convicted under that. But the rules will be adjusted as we need to adjust them to persecute black men, especially black women too, in this country. That's the rule. I can't put it any more bluntly than that.
A question about where the model penal code kind of stands today. Would you say it kind of still leans towards the few steps rule?
Oh, no. The model penal code is the substantial step strongly corroborating criminal purpose. That's the rule under the model penal code, period. If the model penal code applies, as it does in Kentucky on this issue, right? We've adopted the model penal code for the most part, and on this issue, that is the rule, right? So what you are looking for is a substantial step such that it gives strong corroboration, strong evidence that the defendant really had a criminal purpose, right? The Oklahoma case with owning the building, and they accused him of with intent to open a speakeasy, right? Under the model penal code, as in that case, no way you can convict him, because that step of owning a building doesn't corroborate intent because it's totally consistent with innocent, non-wrongful behavior. Okay? It's totally consistent with innocent behavior, then it can't corroborate criminal purpose. Right? So you are looking for things that would not be consistent with innocent, even valorous conduct, right? If it's not consistent with innocent behavior, then it equals corroborating criminal purpose, or at least it tends very much in that direction. So let me wrap this up with what, since we said Rizzo and Murray would not be convicted, would be convicted under the model penal code, would McWhorter? No. The steps he took don't corroborate criminal purpose. Now the alleged statements to the chief of police might corroborate criminal purpose, but not the steps he took. We're looking, did the person take a substantial step or steps that strongly corroborate criminal purpose? Nothing McWhorter did that.
It seems like here, like their unofficial test or their justification for convicting him is just that he put fear in a white person, or a white person had fear that was incorrectly placed. And now, even though he couldn't be convicted under the model penal code, if, let's say, someone were to shoot him out of their fear, it's as if a white person's incorrectly placed fear is justification for doing something to a black man, whereas there is justification for convicting him.
Our rules of self-defense, when we get to self-defense, we will discuss that in much more detail. But I think it's a very nice and thoughtful insight that our rules of self-defense, including the stand your ground rule that has been superimposed upon traditional self-defense rules, does function in somewhat of the same way as the norms and application and the misapplication of rules did in McWhorter, that the law allowed someone's alleged or even actual fear to end up criminalizing black existence or black presence or both, and the stand your ground rule and self-defense rules as they are applied do much the same thing in 21st century America. I think that's quite true. Yeah.
I have a legal question about the end of Rizzo case.
About what?
The Rizzo case ending.
Okay.
So this took place over 90 years ago, and I'm wondering today if multiple people got charged with the same crime, one of them appeals and wins, what would happen to other two people? Do they still have to carry out?
Have they plea bargained? They've plea bargained, you mean? They've reached an agreement, they are not entitled to any relief. Some prosecutors might, unusual prosecutors, might agree to some relief, but if once you plea bargained and accept and reached a guilty plea, that's a conviction, and the time for taking appeal has run, you are stuck with your plea. Yeah.
I do have a question about, like strongly corroborative, especially when it comes to McWhorter. Isn't it kind of still like up to the judge and the jury of like what it means to be like strongly like corroborative? So like their interpretation could be just like really like to a rational perspective, but in 1953 Alabama, it could be another step to the event.
Well, I think that's absolutely true. More to the jury than the judge. The jury has to decide what's strongly corroborated, what steps corroborate intent. So there's a link that the rule explicitly draws between what you did, what steps you took. We know you didn't commit the crime, otherwise you wouldn't be charged with attempt. What steps you took, and does that demonstrate your intent? And the jury has to find that it did corroborate your intent beyond a reasonable doubt. So you're absolutely right, it is up to the jury. So that's point one. Second, I want to, in a strange sort of way, and I don't take this the wrong way, or at least give me a chance to finish it before you jump on it. I don't want to sit in judgment too much of 1951 Alabama for this reason. I don't know how much progress we've made from 1951 Alabama, so who are we to judge? Or we better make a lot more progress before we start getting up on our high horse about 1951 Alabama, because, as Ms. Clements' point suggested, juries today find that fear of black people is totally reasonable and allow people to make self-defense claims. And if those juries acquit, or if prosecutors don't even bring charges, then these are problems we haven't solved. So yes, it's a condemnation of 1951 Alabama, but it's, in my view at least, it's something we need to look in the mirror about as well today. So yes, 1951 Alabama is a problem. ... Okay, let me make a couple of quick points. First, KRS. KRS 506.0101B is where we see the adoption of the Model Penal Code rule in the KRS. Okay? One other way to think about both the KRS and the Model Penal Code is that not only do they change where the line is, but they shift the perspective. Right? They shift the perspective from, or at least the emphasis, from what remains to be done, right? Dangerous proximity test asks, what remains to be done? And it better be very little. The emphasis now is on what's been done from here. It has to be substantial and it has to be corroborated, but it doesn't matter how many steps remain, and are we dangerously near, just what did you do, and what you do, or what you did, strongly corroborate your criminal purpose. In theory, you may have only taken one step, and it might only be a short distance, and there may be 30 other steps still to go. But if it tells us we are left with no doubt that you intended to commit that crime, that's what we're asking. So we're not asking how many steps were left, we're asking what did you do from here. We're asking a specific question about that, but we're asking what did you do from the beginning. Any other questions about that?
So in part 2 of the 501 Model Penal Code section, it gives like specific steps to consider. I'm assuming that's not an exhaustive list, but does the jury get a copy of those to use as a reference?
They would probably, in a Model Penal Code jurisdiction, get those in instructions if one side or the other sought them, to say these are steps you might consider. you may consider, but they would be told, you have to look at any steps for which there is evidence and make the determination whether in your mind they corroborate beyond a reasonable doubt the criminal purpose. That, the judge, I think, would be quite cautious that the judge and the jury might make the mistake of treating it as an exhaustive list, so that they would think, well, if I don't have these, then the prosecution loses, but the prosecution isn't limited to those. Okay? Anything else? Yeah.
I have one question. So in Porter, he was walking on the sidewalk, and that's what he said. And then in section 501, 5.01 on page 725, it talks about lying in wait or searching as what they used to show that that was the defense. So when did that apply if you're not just walking on the sidewalk and following somebody?
When you would think, let's say you're walking on a sidewalk, and you were the defense lawyer for a client, and that's what they did. And the prosecution tried to use lying in wait as the substantial step that shows, aha, this person intended to commit an assault or worse. What would you say to the jury about that?
As a defense attorney?
Yeah.
That it's both illegal and
How would you
innocent.
try to convince the jury not to find your client's actions to constitute lying in wait? How would you draw the contrast?
Yeah, you would give them what anyone that could be waiting for a bus or waiting for somebody, give them what you would.
What does somebody do generally? And how would you try to paint the narrative when they're lying in wait?
Waiting secretly behind something.
They're hiding, right? What would you say about their they're hiding, and how long would they have been there if they're lying in wait?
Probably quite a while,
Right.
waiting for someone, the right victim.
Right, maybe a particular victim. They're a hit person, and they're there to carry out a hit and waiting for that person, because if they kill somebody else, they're not going to get paid, right? So the idea of somebody just walking along the street is kind of the opposite of lying in wait. It's just walking. So that's what I would try to suggest. Now, there could be circumstances in which the prosecution could try to say, follow me, if they were not just walking, but follow. And that's certainly what the prosecution tried to argue in Reporter, is the overlay of all the other conditions we know about and that the Court of Appeals discussed that make that more than dubious. Yeah. But, I mean, that's a great example of where what you want to do is use facts to contrast with legal standards. Right? If the prosecution, or you could flip this and do it from the prosecution's point of view, but if you're the defense and the prosecution tries to use one element of a legal test, if you can point to facts that differentiate what actually happened from what that legal test suggests, like walking along is not the same as lying in wait, then that's how you build a case. That's how you create reasonable doubt. Okay? So you have to creatively look at every individual fact and think through, how would I use that to convince the jury to see this case my way and to show to the prosecution that the elements are met, and if you're the defense, that the elements are not met. Okay? Okay. So that leads us to the very fun issue of abandonment. And this guy is one of the, I don't want to be too harsh to our friend Staples, but this is like stupid criminal tricks. And we would all be better off in this society if everyone was as bad a crook as Staples was. So what happened in 1967 while our friend Staples' wife was away on vacation? And it's Ms. Muir, right?
Yeah. Okay, so his wife went on vacation, and he decided he would
rob a bank vault.
And how would we most do? I mean, I don't want to make heroes of bank robbers or put them up on a pedestal or anything, but how do most bank robbers do their business? I mean, this just sort of, when you see a movie with a bank robbery thing, what usually happens?
They wear a mask
And?
hold the place up with a gun.
Right, they're kind of, they're like Butch Cassidy and the Sundance Kid. Guns a-blazing, into the bank they come. This is a holdup. There's a thrill element to it. They are, there's action involved. Was that Staples?
No.
Not exactly.
He rented the office directly above the vault.
Well, kind of directly above the
A
vault.
mezzanine above it.
Right, so he was on the second floor, right, of this office building. Below this was a mezzanine of the bank, and below that was pay dirt,
Yes.
was the vault, okay? And he knew this.
Yes.
And he what was his, first, what did he do? What were his steps?
Once he rented it, he knew that the landlord had 10 days before he took possession. I think it was October 23rd.
Yeah.
So he only had a month rental of this office.
Because if you can't get a bank robbery done in a month, I don't want to know you.
Okay. So he started bringing in his equipment that he planned to use, including drills, acetylene tanks, rugs, and other things. And
Okay. So far, do we have enough under the model penal code? I'm going to sort of use this as another way to explore the model penal code test before we get to the abandonment issues. Do we have enough to say that he has taken a substantial step that strongly corroborates his criminal purpose?
I say yes.
You say yes. So you're going to be our prosecutor. Make that case.
Okay. The office that he rented didn't have a purpose listed for it other than
What steps are you going to tell the jury? Here are the steps, ladies and gentlemen, the jury. Step or steps that Staples took that strongly corroborate his criminal purpose.
bringing the drills and acetylene tanks up into there and locking it in a closet.
And because those steps are not consistent with innocent behavior.
In this case.
Okay.
I'm
Now I need Staples' defense lawyer.
So like those are just like regular normal people's steps. It's just tools.
Just tools.
It's just the rental property.
He
It's an
could be
innocent
intending
act.
to do some renovations, right? He could be a handyman. This is consistent with innocent behavior. Might be a little peculiar, but Staples is already striking me as a peculiar guy. Do we put people in jail for being peculiar?
No.
Thank God. Right? So there's the argument. Both sides are going to try to convince the jury to see these facts, and a couple more as he goes on his merry way, as meeting the test. So the test doesn't resolve every ambiguity. Juries have to look at the facts and decide, aha, were these substantial enough to corroborate his criminal purpose? Okay. He's going to resolve any doubts with his things he says. What else does he do? What does he do on October 14th?
He starts to drill some holes into the floor above the mezzanine, but he doesn't drill all the way through.
Right? Because he's got a month. He can take his time,
Yeah.
and he does this on a Saturday when no one's there.
We know it's, because he found out from the custodian, no one would be there on Saturday.
How is your defense holding up now when he's drilling holes in the floor?
It's still hard to see like what he's trying to do.
I beg your pardon?
It's still hard to see what he's trying to do.
He
So
could be
just
drilling the
like doing
holes
something.
because he's trying to anchor furniture. Or, people do drill holes in floors for reasons of construction or remodeling, who knows? Okay, so we're still good, okay? How did this all end?
So he put his tools in the closet and tried to lock it or planned to lock it, and then left them there.
He left the keys there so somebody could get in.
And left the closet key there too.
So, sometime after his lease ends, what does the landlord do?
The landlord buys them and calls the police and turns everything over to the police.
And his lease expired on the 23rd. He didn't enter the premises again after that date, and maybe not for days or weeks before, right? He may have just sort of not continued. When did he get arrested?
February 22nd.
February. So November, and now we have to December to January, 3 months. What do you think was going on? Put on your I'm the police investigator hat. What do you think was going on?
Waiting until it gets too dangerous?
I beg your pardon?
Waiting until it gets too dangerous?
No, I don't think that was it. What do you think they were waiting for? I beg your pardon? No, his wife was only gone for like 10 days, I think.
I thought he was gonna return and then maybe do.
There you go. The police were thinking, we're gonna wait, see if he comes back and continues his endeavor, because the more evidence we have. Remember, at this point, before they arrested him, they hadn't talked to him. He hadn't made any of the really dumb statements he made, right? So they would want to wait and see, is he gonna give us more by his actions that might help us to cinch the case? Because at this point, it's not such an open and shut case based on what we know. And so the police wait. Police wait till February. Finally, they decide, okay, we've waited long enough. He's not coming back, and they arrest him. Okay? And what is one of the prime lessons of this case for any good defense lawyer?
Well,
Because what happens next?
he said he changed his mind. He had a change of heart.
Well, what is that? What is the implication of that?
Tell your client not to incriminate himself.
I beg your pardon?
Tell your client not to incriminate himself.
Tell your client to shut up. Right? The worst thing that can happen many times is for the defendant or the arrestee to start talking. Because basically, Staples gives more corroboration that there was not truly an innocent explanation. That what might have been an innocent explanation for his actions wasn't. The innocent explanation was not consistent with the facts, right? He says he started to think about the implications of what I was doing. Well, he wouldn't say that if the implications of what he was doing were completely innocent, would he? What else did he say?
Well, he said he didn't want to live the fugitive lifestyle.
Which, if his explanation were innocent, he wouldn't have to have a fugitive lifestyle, right? And he would prefer, what did he say he would prefer to a fugitive lifestyle?
His boring mathematician life.
His boring mathematician life. And there's lots of great things about that statement. One of the great things about that statement is that mathematician is the word of the day. Mathematician.
She did. She said it.
I mean, when you have somebody telling the police that a life as a fugitive, even with lots of money, would not give the enjoyment of the life of a mathematician, you know it's time to plea bargain. And then he says, the worst thing he says, from your point of view, if you're his lawyer, great, best thing he says if you're the prosecution, Mr. Webb.
He said, I still had not given up on my plan.
And what does it tell you when he says, I had not given up on my plan?
Abandonment's not gonna work.
A, he's torched, with the acetylene torch perhaps, he's torched even his abandonment defense, but as to the issue of substantial step, what is implicit in the statement, I have not given up my plan? That he had a plan to begin with, right? This is the sound of him nailing shut his life as a non-felon, right? He's nailing that shut. And it certainly hurts his abandonment case as well. But given all of this evidence of his intent and the steps that he took and what they signified, given what he said about them, it's no wonder that he makes an abandonment defense, right? This was not preparation, the court says on page 736. There was sufficient evidence from which the trial court could find that they went beyond mere preparation, that he actually had commenced the plan, right? He had started to carry out his plan. It wasn't mere thought, wasn't mere preparation, it was an attempt, okay? So what do we get, even though it seems awfully weak, given that he said, I had not given up my plan? He argues that even if it was a sufficient attempt, he had abandoned it. And as his defense lawyer, what is your argument that he had abandoned his plan?
That he changed his mind.
And how do we know that he had changed his mind?
His wife came back and it seemed more remote that he would complete his act.
He said it seemed ridiculous to me to be a bank robber. Give me two different cases of attempt. One of which would be, again, we're going to play with extremes here, where it would be ludicrous to even claim that you possibly could have abandoned. What would be the worst case scenario in an attempt prosecution to be able to claim on behalf of your client that he or she had abandoned the crime?
So what do you mean, because he's begun the drill?
How do attempts, let me put it another way, how do attempts sometimes end when they don't end in the completed crime?
They get caught.
They get caught. And that would be the worst case scenario for abandonment. So it's like Rizzo, right? Rizzo didn't clearly abandon. Rizzo got caught by the police, right? Now, didn't come dangerously near. So that would be a ludicrous case for abandonment. What would be the best case for abandonment?
There was an outside interference.
There was outside interference? No, that's not good. You voluntarily saw the light, right? You was like, you know what? This is wrong. This is just bad on my part. There's no risk you're going to get caught, at least in your own mind. That is not a motivation for your abandoning. You don't actually get caught. That kills your claim of abandonment. But you say, I'm going to just not do this. Does Staples, forget his statement, I still had not given my plan. But what are the facts from which you would try to construct this abandonment defense in his case?
I'd say on his statement that...
Don't focus on the statement. The statement's a killer for you.
All right.
What are you going to focus on the facts of what he actually did?
He stopped.
He stopped. And he stopped, when did he stop? At least the defense would argue. I'm sorry?
Before he made a substantial step.
Well, no, because if he didn't make a substantial step, it wouldn't be an attempt at all. So we want to have this, we're in this sweet spot between saying, yes, he took a substantial step, because that's your first argument, and the court rejects that. Right? Okay, yes, even if it was an attempt, even if it was a substantial step, he abandoned after that. What did he do to abandon? On the facts, what did he do to abandon? He never came back to the office, right? And he came back, or at least the facts suggest maybe he stopped going to the office even before the lease expired, right? And he didn't take any more steps. In the 3 months, the police waited him out. They kept waiting, and he kept not trying to rob the bank. So the defense can say, look, what more do you want as evidence that he abandoned? Does that work for you and your clients? Why not?
They said that if it weren't for the landlord turning and everything to the police, then he might have still gone back.
So there was enough evidence that he had not fully abandoned, right? Enough evidence that he had not fully abandoned. And it's not an implausible case for abandonment, so that perhaps the jury could have found that if the jurisdiction allows for abandonment, but there's no requirement, right? This is one of those cases where once the trial court comes to a decision there's evidence to support it. What we're looking for, is there evidence to support it? And the court says, yes, there's evidence that the jury could have found that Staples became aware that the landlord had resumed control and had turned the defendant's equipment over to the police. That is interception, right? That is the equivalent of the police catching Rizzo. It's a little less direct, but it's enough. Then the court goes even further. The court goes even further and says that once a tent is found, there can be no exculpatory abandonment. So in this jurisdiction, it's California, the court says, we're going to reject even the idea of abandonment. There can be, once you hit this point, no abandonment. That is an extreme rule, right? MPC and the KRS both have a limited abandonment rule. Very limited. If you look at note 2 on page 737. For the Model Penal Code 5.014, there must be a complete and voluntary, emphasis on voluntary, renunciation of the defendant's criminal purpose. The abandonment of the criminal scheme cannot be motivated even in part, by circumstances that the, let's say, Staples becomes aware of that increase the possibility that he may be detected or apprehended, or which make more difficult accomplishing the criminal purpose. Right? So if your motivation is, oh my gosh, I think I might get caught, or this crime just got harder, that's not voluntary. You are being motivated by forces outside your own moral compass. Okay? So even if that's part of the motivation, the prosecution can show that, you don't get abandonment, even if you otherwise did all the things that would constitute abandonment. KRS 506.020 is similar. The wording is a little different, but it's very similar. Both provisions require the defendant, both KRS and MPC, not merely to have abandoned the criminal intent, but also, in the words of the KRS, to take the necessary affirmative steps to prevent its commission. To take the necessary affirmative steps to prevent its commission. So I have two questions about this part of the abandonment rule. Okay? The first question is about the agency. What happens if the police prevent the commission of the crime? The crime does not happen, but it's the police who do it. Does this rule give you an abandonment defense? Anyone?
No, it's involuntary.
I'm sorry?
No, because it's involuntary.
No. It's not a question of voluntariness. If you do nothing to prevent its commission, you the defendant, you do nothing. So it's not whether what you did was voluntary or involuntary, but the police prevent it. Does this give you an abandonment defense? No. You have to be the one who causes it not to happen. You must take the necessary steps to prevent. Okay? So that's one thing. If it's just that something else gets in the way, but you're not the one who got in the way, that's not going to get you abandonment. Okay, the second question is, if the person has abandoned the crime, why would it ever be necessary to take steps to prevent its commission? Why wouldn't simply abandoning be enough to prevent its commission? Or at least under what circumstances would abandoning not be enough?
If you were conspiring with other people?
Others. Good. This is really about situations in which others have been involved. So you abandoning, saying, I'm out of this. I have seen the light. I understand now how wrong this was. I'm out. You abandoning is not enough. If there are others involved, you must take the necessary steps to prevent the commission of the crime. If you just back out and do nothing other than back out, and then the police prevent your co-conspirators from achieving their goals, you have not abandoned, because you did not prevent the commission of the crime by those others, the police did. So it's a very stringent rule. You better not just back out, you better see to the prevention of the crime. And we will, when we get to conspiracy, we'll see this again.
That last added provision, is that only under KRS or is that under?
That's under both. Okay? Yeah.
Which KRS was it?
KRS 506.020. Okay? I'll see you guys on Wednesday.